Шановні колеги, ми будемо розпочинати.
Dear colleagues, we start our working day at Ukraine Crisis Media Center, and the topic of the first press briefing, trial in absentia, dilemma for Ukraine and Jordash QC, managing partner of RC Global Rights Compliance.
Thank you. Trials in absentia are a hot topic in Ukrainian legal circles today. Whilst they have always been allowed under the Criminal Procedure Code of Ukraine, in May 2016, with the prospect of a trial against former President Yanukovych looming in the background, new transitional provisions were brought in that modified the law. As a result, the topic of trials in absentia have been thrown back into the spotlight, and the new provisions have come under some criticism. Global rights compliance has looked at the international legal issues that appear to be at the heart of many of the critiques. Namely, one, whether trials in absentia violate international human rights law, and whether holding them in Ukraine will impact on the prospects of the same cases being tried at the ICC, the International Criminal Court. I will address each of these in turn. So the problem at the beginning with the absentia proceedings is that the primary and overriding duty of a criminal court is to conduct a fair trial. The defendant is and always must be at the center of the process. To conduct a trial without the accused is like trying to stage Hamlet without Hamlet making an appearance. The story of Hamlet cannot be fully told without the prince himself on the same stage. It just isn't the same play. For this reason, international law is cautious about in absentia proceedings, and they have generally been absent from the international arena since the post-World War trials of Nuremberg. They're not permitted at the International Criminal Court. They have been allowed in one court, the Special Tribunal for Lebanon, and they have been a source of considerable controversy. Turning to national jurisdictions very briefly, the approaches vary. Some, and the majority of common law states, outlaw them absolutely. The approach of civil law countries is more flexible, but still very cautious. For example, Austria and Germany allow them, but the range of sentencing options is restricted. In fact, very restricted. In Austria, the maximum penalty that may be imposed following in absentia proceedings is 3 years imprisonment. In Germany, no custodial sentence may be imposed at all following a trial in absentia. The importance of the presence of the accused at the trial is reflected in various international treaties that Ukraine has signed. Firstly, Article 14.3d of the International Covenant on Civil and Political Rights, the ICCPR, and Article 6.3 of the European Convention of Human Rights. A person facing a criminal trial has the right to be informed of the charges and to be tried in his own presence. Nonetheless, despite the mandatory terms of the ICCPR and the ECHR, no international or regional human rights treaty prohibits holding proceedings in the absence of the accused absolutely. There is general consensus internationally that the rights of an accused to be present at his or her trial is not absolute and may be subject to certain restrictions. So when are in absentia proceedings lawful? When can these restrictions come into play? There are two general scenarios. One, where an accused is removed from the court for disruptive behavior and the prosecution or court decides to continue the process. Or two, where the accused simply doesn't show up for trial or ceases to attend midway through. In the first scenario, the disruptive defendant is removed because he or she has abused their right to be present. As the European Commission on Human Rights has held, the right to be present does not include the right to filibuster or delay or disrupt one's own trial. The second scenario, where the accused doesn't appear for trial, is the scenario which is obviously most pertinent to Ukraine's current landscape. Two essential points must be made. Firstly, if a decision is made to continue in the absence of the accused, it can only be lawful if there has been an unequivocal waiver by the accused or the suspect. Secondly, in cases where there is less than an unequivocal waiver, the governing legislation must guarantee a retrial. Let me deal with both of these in turn. First of all, unequivocal waiver. In summary, as international human rights law recognizes, the fundamental right of a person to be present in the proceedings may be waived by that person if that person has been shown to be actually notified and actually decline to attend. As decided by the UN Human Rights Council, in the case of Malaiki versus Italy, the state bears the burden of demonstrating that the accused has been summoned in a timely manner and informed of the proceedings against him or her. It is the obligation of the court to verify that the accused had actual knowledge about a case before commencing a trial in absentia. The same is true under the European Court of Human Rights. In a case against Italy, the court noted, quote, "To inform someone of a prosecution brought against him is a legal act of such importance that it must be carried out in accordance with procedural and substantive requirements capable of guaranteeing the effective exercise of the accused rights. Vague and informal notice cannot suffice." So, where does that leave us? Where an accused has been informed of the charges against him or her, a trial in absentia is lawful. Where the state has not demonstrated actual knowledge, but has only demonstrated likely knowledge, this is not sufficient. Knowledge may be inferred, for instance, where the accused received a summons, or otherwise indicated his or her knowledge of the trial. For example, where the accused instructed his lawyers to attend the trial, obviously the accused knows about the trial, has actual knowledge, and in those circumstances appears to have waived his right to attend. But a mere assumption that the accused was aware, say for example that the trial was widely publicized in the media, will not be sufficient. The right to attend a trial that accused has no idea is happening is in reality no right at all. Secondly, a guaranteed right to a retrial. This is critical. Where there is any doubt regarding the accused's knowledge of the proceedings, the state must guarantee, and I emphasize the word guarantee, a retrial in the event that the accused is apprehended. Anything less will violate the European Court of Human Rights law. This is particularly important in the context of extradition. A state may refuse extradition. A state belonging to the Council of Europe may refuse extradition where a state does not guarantee a retrial for defendants convicted in absentia. This is provided for by Article 3 of the Second Additional Protocol to the European Convention on Extradition of the Council of Europe. What does this mean in practical terms? Let's take Yanukovych. If he's tried in absentia and there is doubt as to whether he knew about the proceedings and he's then detained in Germany, Germany will be under no or much less of an obligation to extradite Yanukovych back to Ukraine. So these things have real practical consequences. Turning to the Ukrainian code, which deals with in absentia processes, as you will appreciate, in light of the law that I've just outlined, there are aspects of the Ukrainian Criminal Procedure Code which are problematic, to say the least. In summary, the code appears to allow in absentia proceedings where there has been a failure to establish the whereabouts of the person, Article 42, where a summons has been sent to the last known address of a suspect and it has been published subsequently in the media and official websites of the authorities. Paragraph 5 of Article 297-5 of the Code. And also where the accused is abroad or in occupied ATO territory, again, the Ukrainian Criminal Code appears to allow trials in absentia. As will be obvious, none of these thresholds require actual proof that the suspect or the accused knew of the prospective proceedings. And importantly and critically, none appear to guarantee the right to a retrial if in absentia proceedings are initiated on this basis. This means that the provisions as they stand may well violate international law. I say may well because there are a number of articles in the Code which might be used to reinterpret these provisions. For example, paragraph 2 of Article 7 of the Code obliges the prosecution to, quote, use all available means to ensure respect for the rights of suspects and accuseds in absentia proceedings. Paragraph 1 of Article 297(1) of the Code provides that, quote, in absentia pretrial investigation may be held in cases of those who went into hiding from investigation and court in order to avoid criminal responsibility. These could be interpreted as an obligation on the state to demonstrate that the suspect has actual knowledge about the proceedings against him or her and has deliberately chosen to flee. However, given the definite and specific language of the provisions which appear to allow trials in absentia with something less than actual knowledge, this situation is far from clear and they may well not be able to be interpreted in accordance with international law. Moreover, even if they can, the lack of a guarantee of a retrial remains an enduring and significant problem. Turning briefly to the question of the ICC. Trials in absentia will not impact on the ICC's jurisdiction. Whilst the Ukrainian judiciary should ensure that it has relevant expertise and processes fit for the purpose of trials, the conduct of in absentia trials or investigations in Ukraine will not impact the work of the ICC. For these reasons, in brief, the ICC may consider a genocide, a crime against humanity, or war crimes case only if Ukraine is not willing or not able to investigate or prosecute the case itself. According to Article 17(3) of the Rome Statute, if the state is unable to obtain the accused, then the ICC will conclude that the state is unable to prosecute. In those circumstances, the ICC will insist on the case being tried at the ICC. In summary, the best evidence of an inability to obtain the accused is, of course, a trial in absentia, i.e., because the state doesn't have custody of the accused. In the Libyan proceedings at the ICC, the failure of the state authorities to obtain Mr. Gaddafi was fatal to their challenge to the ICC's jurisdiction. The prosecutor in that case stressed that, quote, what is relevant is whether the state is unable to obtain the accused and not whether or not a trial in absentia is possible. The pretrial chamber ruled that Libya had not yet been able to secure the transfer of Gaddafi from his place of detention under the custody of a militia. The failure of state authorities to obtain the accused proved the inability of Libya to conduct a proper investigation and prosecution of Mr. Gaddafi. This made his case admissible before the ICC. So rather than in absentia proceedings in Ukraine making it less likely that the ICC will step in fact, they make it more likely. So in conclusion, Ukraine's in absentia provisions are a brave step into a complex judicial arena with all manner of legal and factual hurdles that will require more than willingness to negotiate and overcome if adverse European Court of Human Rights findings are to be avoided. This is not a reason to avoid trials in absentia, but it is a reason to advance cautiously and precisely to ensure that any judgment is the product of genuine adjudication, respecting the presumption of innocence. At least as concerns senior leaders suspected of international crimes, if this goes wrong, and let's face it, they often do, Ukraine can rest assured that these cases will still be on the ICC's radar and may eventually lead to convictions and the enforcement of sentences. Thank you.
Thank you a lot. There are at least two questions from my side. The first one is, I'm going to ask it in English, just in case. The first one question is, recently the ICC prosecutor issued her annual report on preliminary examination activities. Can you comment on the situation regarding Ukraine? What are we looking at and what to expect?
Well, there are a number of significant findings in the, or at least preliminary findings in the ICC's prosecutor's annual report. In relation to Euromaidan, she remains unconvinced that the crimes amount to crimes against humanity. In particular, that she remains in doubt whether they took place within a widespread or systematic attack. She remains open to persuasion. In relation to Crimea, the most significant finding was that she has come to the preliminary conclusion that there is an occupation by the Russian Federation of the Crimean territory. This amounts to an international armed conflict, and therefore she will continue her preliminary examination to ascertain whether violations have taken place within that international armed conflict which amount to war crimes. She's identified a number of potential war crimes against Crimean Tatars, including forcible transfer and various crimes relating to murder and possible persecution. She again remains open and is continuing that examination, but it looks optimistic from Ukraine's perspective. In relation to the East, she has found that there is a non-international armed conflict with possible violations on both sides of the conflict. She is examining further whether there is an international armed conflict between the Russian Federation and Ukraine. And that's something which she specifically spoke about as something which she's now looking specifically into. Again, in relation to the East, as with Crimea, I think she's given some very optimistic indications that she is moving towards opening a full investigation, but we will see. But that's my reading of it.
And one more question. What kind of additional information does the prosecutor need in order to state that there is an international armed conflict between Ukraine and Russia?
Well, in Crimea, I think it's a much more simple, straightforward situation, and I doubt very much whether she will not arrive at that firm conclusion. The facts seem obvious. In relation to the East, it's much more complicated. There are two ways in which she may find there's an international armed conflict. Firstly, that the Russian Federation is directly at war with Ukraine, two armies facing off against each other. And she has made a preliminary finding, which is that there is indication that the Russian Federation is involved directly in the conflict. So she's investigating that further. And what's required, I think, from the Ukrainian side is more information which identifies direct participation by the Russian Federation in providing logistics, in involving in actual conflict, in sending Russian soldiers. Any participation by the Russian Federation through its army itself or through intermediaries such as Russian soldiers will be good information which will be useful for her to make that determination. The second way of finding an international armed conflict in the East is for the prosecutor to be satisfied that the Russian Federation is in overall control of the armed groups in the east. So she will look at whether their intervention, if there is intervention, whether it's sending of Russian military or sending of logistics, places Russia in control, actual overall control of the armed groups, so that their conduct can be directly attributed to the Russian Federation. Again, the evidence she requires for that is similar to the first, in the sense of any intervention by Russia will be evidence of a degree of control, but in relation to this aspect, she will need to see something much more like effective command, so that the sending of Russian soldiers, for example, may be evidence of an international armed conflict, but she would need that one step further to see that those Russian soldiers are in command of the separatists and defining, furthering the command of the armed groups and their operations.
Thank you. Чи є ще запитання або коментарі, колеги?
Any questions or comments?
At this point, the press conference is closed. Thank you for coming and looking forward to seeing you here in the nearest future.
Thank you.